SJC-13678 in the matter of an impounded case.
Okay, Attorney Schreiber.
Chief Justice, Associate Justices, good morning. May it please the court. My name is Raj Schreiber, and I have the privilege of representing the defendant in this case. The foreseeable future for this defendant on August 9th, 2024 was exactly the same as it had been for years. All of the experts, including the Commonwealth's own expert, had come to the realization that this defendant was unlikely to ever be restored to competency. And
When was the last such evaluation?
that would be by Dr. Johnson, Your Honor, and that was in April of 2022.
So 2 years before?
2 years and about 3 months before this bail hearing. So that was the last evaluation, but all of these experts had agreed that this individual suffered from cognitive deficits that were untreatable and would not improve with time, and had opined in one way or another that remediation was not going to work for him. So this defendant was in the same situation as the juvenile in Makis M, where this court found he's not competent due to issues other than mental illness. There's no road to remediation. Therefore, we cannot expect him to attain competency in the foreseeable future. So that was the state of this individual when he came before the Superior Court judge on the bail review.
Can I just ask, just preliminarily, why is this case not moot, and why is it capable of repetition but evading review, given that
So
we have a situation where the defendant doesn't have or isn't able to post bail?
right, thank you. I'll try and answer your question best I can. So as this court has recognized in the past, these short periods, relatively short periods of incarceration or detention or bail revocation or being held can escape review because they run their course before appeal can be perfected. And so this issue is going to escape review. And in my client's case, in the defendant's situation, he's charged with a life felony under Chapter 123, Section 16F. His half time or his potential relief time is 9-10 years away. And during the proceedings, the life of these proceedings going forward, it's very likely that we could be facing the same issue. I'd have to be up here again on a similar question. And I think that a few other things, I guess, militate towards considering the issue. Number one, we've briefed the issue. It's a fairly new and important issue. And the trial judge squared the issue as a pretty clear challenge to Abbott A, where he understood Abbott A, he understood Jackson v. Indiana expressly on the record. He understood that he might be violating due process by causing this defendant to be held by setting bails, but he nonetheless and expressly stated, I'm going to do so in the interest of public safety, and this can be subject to appeal, which is why we're here today. So
can I ask you a question about that? So you mentioned the trial judge's reliance on Abbott A and Jackson, and so do you. But at the start of talking about why this case wasn't moot and the concern that it might evade review,
right,
you mentioned the relatively short period of being held. Now,
right.
So now within the context of Abbott A and within the context of the federal case, why is such a short period of incarceration? Why does that shock the conscience?
So first of all, Abbott A and Jackson v. they don't talk about shock the conscience standard. They talk about, Abbott A talks about this three-prong process that you go through. Abbott A, this court never mentions shock the conscience. So there's a three-level analysis to go through. But to at least, I think to try and answer your question, first of all, we need to know, I guess, what is the period that this defendant was detained? Was it from August 9th, 2024, or was it from the day that his case in Dorchester was dismissed, therefore vacating his $30,000 bail as a matter of course? Or was it that 3-day period? So I would suggest our law recognizes when someone is serving a sentence or someone is being held, even pretrial, our law recognizes that they're getting credit as if they're in custody. So there's an argument here that in our law recognizes that an individual is held in custody from the date that a bail is set and he can't post it. But I would argue respectfully, Your Honor, that even a 3-day custody in this case would violate Abbott A in these circumstances, because it was very clear, I would say, abundantly clear, and Commonwealth stipulated these facts, and these stipulations that are still in force. They haven't been vacated. They stipulated these facts that he is not restorable. Everyone knew what the situation was.
The Commonwealth gets because it's fluid, the Commonwealth still has a chance to have the person evaluated, right? It just doesn't,
Sure.
You don't get to have a competency, even though restoration order stand with the individual defendant. Every time the problem is he keeps committing crimes.
Right.
Right.
Right, so that's why we're here.
Exactly.
So the Commonwealth has to have, there's a competency evaluation for every new crime.
So, correct. Well, I'm not going to concede that, but I think what you're saying is that, excuse me, I might have spoke out of turn, but what I'm saying, yeah, you're right. So you're right. They can ask for another competency hearing and a judge can order. And that's in fact what's happened post-petition,
Right.
which is immaterial to our analysis here. But yes, I'm sorry, that's absolutely 100% correct.
It's not really immaterial though, because if you have somebody that continues to commit crimes and serious crimes, and the Commonwealth has an opportunity for reevaluation, are you suggesting that every time you have somebody who's incompetent that due process requires that they be released, and that the judge can't impose any reasonable restrictions?
No, absolutely not. So the law, as I understand it, under Abbott A, is that if there is no substantial probability that a defendant can be restored, if there's no showing of that, he cannot be caused to be held in custody, but he can be subject to conditions. And those conditions can address public safety, for instance, GPS, home confinement, call into your probation officer, stay in, work.
But not a bail order.
I'm sorry.
But not a bail order?
Well, this was a bail order. This was not a 58A, but under the bail statute, as I understand it, under Brangen, you can consider public safety when setting conditions in lieu of bail.
Didn't he commit one of the crimes with his GPS on? That's how they caught him, right?
Well,
So
correct.
So it seems like we're in a catch-22. You can't. The conditions don't work. He keeps committing crimes, and he doesn't have the mental illness component that allows a civil commitment. So we're kind of in a quandary, right?
Well, right. So, and that was the same
What
quandary.
do you suggest we do? What is?
So
How
that's,
does it shock the conscience to do what the judge did, given this quandary?
all right. Well, that's the quandary, I guess, is one side of the ledger. The other side of the ledger is the fundamental rights that this court and other courts were created to, in part, protect. So that's the weighing of it there.
We've struggled with this issue in other cases. The difference in this case is your client made bail, so it may be moot.
This case is, I guess, somewhat similar to Commonwealth v. Wakan, the single justice decision by Justice Lowry, where he said this is an extremely dangerous defendant, but he cannot be held under Abbott A, but he can be subject to conditions.
We had that in the juvenile case as well, correct?
Yes, Your Honor. So it is a quandary, and in Makis M, I think the court had left it to the legislature in one aspect of it to address remediation programs, and you could have, perhaps for people such as this defendant who was not incompetent due to mental illness, some sort of structure that could apply in a case and in this situation, but we don't have that. And so you might be right in that there's this hold.
One question so procedurally, we're here on an appeal of the single justice decision.
Right.
One of the things that stuck out to me was the single justice said something about that the competency evaluations here were not unequivocal, that there was some wiggle room in there. So why would it be an abuse of discretion here in light of the fact that some of these competency evaluations aren't as ironclad as you claim they are, or that at least the single justice didn't think so?
So respectfully, Your Honor, there is 3 evaluative reports. The only report that cites sort of the language that the Commonwealth is going to be talking to you about is the first in time report, 2020, January, Dr. Muniz's report. And yes, she talks about there's some evidence he's exaggerating. There's lack of effort here. There's malingering, so-called. But even considering that, I'm going to opine that he's not competent due to genuine cognitive deficits that are not going to change over time, and he's not a candidate for competency remediation. That was her ultimate conclusion. And so in that respect, it shows that a very able and dedicated forensic evaluator who's putting all the facts forward and then coming out with a conclusion. And the conclusion is, notwithstanding these factors that my brother will talk about, he is not competent, not likely restorable.
That's as of April 2022, correct?
No, that's, I'm talking about Carla
You're talking
Muniz in
about
2020.
You're talking about and then in April 22, you're relying on that one, correct?
All of them are in
All of them.
agreement.
All right, but the one closest in time before the decision here is the April 22,
Yes.
correct? And can we at least agree that these mental status or incompetence is not static? It isn't just, it needs to be evaluated over time?
So the issue here is that all these evaluators, not just there's other evaluators before when he was a juvenile, which we don't have access
Sure.
to those reports in the record, but they all agree that this is borderline intellectual functioning. It's not going to get better in time. These CST abilities are related to this, and it's not going to improve. And so what these evaluators are all agreeing is he's not going to get better. He's not, and the last evaluator said there's no need to ever, there's no reason to examine him again. And so, and here we are. And the Commonwealth, of course, has its stipulations that it has to get by its stipulations. It has to get past these evaluative reports, and it has to get past Abbott A. And so that's the situation. These facts are probably, look to me to be very tight on the side of this was a violation of Abbott A in these circumstances.
Okay, thank you.
Thank you. My time is up. I'll rest on the brief. Thank you.
Thanks. Okay, Attorney Steinfeld.
Thank you very much. Good morning. May it please the court. My name is Kenneth Steinfeld, and I'm appearing today on behalf of the Commonwealth of Massachusetts. I think that straightforward application of a rule, which this court has said is deeply rooted in the common law, that courts do not decide moot cases. And if any case were moot, this is it. He asked for the relief that he be released. And 3 days after, he became held solely on the bail orders that are at issue. He was, in fact, the petition was denied, and then 7 days later, he was released. So he was held for a total of 10 days solely on these bail orders. And that is, as I say, just not the stuff that substantive due
But can
process.
you address the argument that this is capable of repetition?
Yes, because of the mental state of this defendant, and the state that he is in, where his lack of competence to stand trial is based solely on his borderline intellectual functioning. Yet he has the capacity to commit and the proclivity to commit violent offenses and drug crimes. I don't think you're going to find a whole lot of defendants, fortunately, who bring that problem. I think he's a serious problem for the Commonwealth, potentially in the future.
It's even capable of repetition by this defendant.
Yes, it absolutely is. And as I say that in my brief, that's not the stance that this court means. And if and when it does repeat in this case, we will have a very, very different record. There is a hearing scheduled in December for competence. There's been further reports filed. So should he be held more than 7 days or 10 days or 3 days, then the issue of whether his detention violates substantive due process will have an entirely different record. And some decision in this case, based on this record, will have no effect or impact or guidance as to whether or not he's being held. Suppose he's found not competent in.
Is that right? Because there would be a precedent out there that, I mean, Judge Ullman was faced with a very difficult problem. And there would be a precedent out there saying, here's what you do in these circumstances. So that wouldn't be valuable for, even in the next case where there may be difference in facts, but at least you'll have some guidance on the particular issue that we're confronting here, which is this person who falls into this bizarre category, which is he can commit crimes, but he's been consistently found not competent, and he's not capable of civil commitment. You don't think there'd be value in?
Well, there would be some value, of course, to all decisions, but I think that the law in this area is very well established by Abbott A. And in here, in fact, the judge went through each of those steps and he reached a conclusion by fairly and properly weighing them. There's no.
And again, just,
Sure.
Attorney Steff, I don't mean to cut you off, but isn't the first factor of Abbott A, which is that he is capable of becoming competent, that's difficult here, right? Because we've got a bunch of experts saying he's not.
Right, but the first factor says that he may be held for a reasonable amount of time to determine whether or not he may become competent. And that clock only started here on the 24th of September, so a very short time. I don't think there has to be a very obvious possibility that he will be found competent, just a reasonable possibility that he may be found competent. He cannot be held for a period longer than that.
The expert testimony here is, most of it says that there's no chance here, and he's been this way for so long that we're in this dilemma.
Well, the stipulation says it is unlikely that he will be restored to competency. But as I point out and has been pointed out, the experts' reports are professionally and properly hedged is the wrong word, but they contain, as Justice George has said, a lot of wiggle room. Seems to be doing this, presents as that, clearly lacks effort, clearly says, I don't know, over and over and over again. I think if you read the reports from Dr. Johnson, Dr. Bell, and Dr. Munoz, they are filled with I don't knows when a question pertains to his ability to understand the proceedings, but not as to other questions. So I certainly think it's reasonable.
Guy's committed a bunch of very serious gun offenses, and each time he's been let out because you can't try him. You don't want any more guidance on what to do on that.
No, and that's my next point. This court has made very clear that you have to weigh. Of course, the liberty interest here is huge for this defendant, but so is the interest of the citizens of the Commonwealth not being injured by dangerous defendants who commit violent crimes, drug crimes, gun crimes. The danger to the Commonwealth remains the same if he's competent or not. So there must be a way, there's got to be a mechanism for the Commonwealth to protect its citizens against a person like this who presents with a unique state of mind. And here I think that the procedures in place established by Abbott A and is very thoughtfully worked through by Judge Ullman led to the proper result. You can hold him on bail, $5,000 bail. And if he could not have made that, and then he were held for a period significantly longer, most of the cases discuss periods of months or a year or 18 months or up to 2 years for COVID. So right now, there's definitely no way that the amount of time that he's been held violates substantive due process. And the issue absolutely is shocks the conscience. That's the standard for a due process violation. And the three factors set out in Abbott A are how you determine whether or not it shocks the conscience. So it's not a separate test set out in Abbott A. It is how you determine whether or not the conduct of the Commonwealth shocks the conscience. And here, I think it's fairly obvious that it does not, because of the dangers he poses and the short duration and the finding that he's definitely...
Can we consider the danger that he poses, given that this was not a 58A?
Yes, because of the third factor of Abbott A. The issue here is not whether the bail was set too high because of dangerousness. It is the third factor of Abbott A, the court has to consider the length of
Can
detention.
I ask you to, before you finish that, Abbott A was a 58A,
Yes,
and this is not.
right, but
Okay, so
When
so in
determining-
light of that, how does the dangerousness fit into that Abbott A analysis if you want us to
Right.
apply it in a 57?
Abbott A sets forth the standard when a person who is not competent is being held, period. I don't think that there's a significant distinction in this case between being held on $5,000 bail and being held pursuant to 278A. I'm sorry, to 58A. And the same factors would apply when determining whether or not that detention violates substantive due process. And one of the factors is the dangerous of the defendant posed to the community. That's how we help to determine whether or not his right to due process has been violated by his continued detention. And also the seriousness of the crimes and those things weigh very heavily on the side of not finding a violation of his substantive due process because of the nature of the offenses as I've set forth. I hope that answers the
Well, I mean,
question.
it answers the question. I guess I'm still struggling with the fact that Abbott A was a 58A detention, and so was entitled to all those procedural safeguards that are in 58A.
Well,
Here, this defendant did not receive those procedural safeguards.
he did have
Your
a...
answer is that once he's in under 57, then we don't need to worry about the procedural safeguards attendant to dangerousness when determining substantive due process violations.
There are two things. He certainly could move. If he were being held, he could move again to have his bail lowered and then appeal that if it's denied. Or this court in Abbott A in the last paragraph said, as a matter of this court's superintendent's powers, it's going to order a 90-day hearing each 90 days to determine the status of the defendant held under 58A. And I think that should a defendant be held long enough for those concerns to be valid, which I don't think is reached, this court could certainly do the exact same thing and say that a person held because he can't make bail as opposed to being held on 58A shall have an evaluation every 90 days, every 120 days, whatever it is, to make sure that the parties in the court are on constant vigilance as to whether or not he's still a danger and as to whether or not there's a possibility that he may become restored to competence. I see that